Hello landlords, it's Ernie Garcia, landlord attorney, and today we're talking all about rent relief. Is it still a thing? It's still a thing. Let's get started. So in the state of Texas, anyway, on October 31st, 2022, the Supreme Court extended the 56th emergency order regarding the COVID-19 state of disaster. And in this order, it extended through the end of the calendar year the rent relief program that is currently in place and the rules regarding rent relief currently in place in the state of Texas. This means that tenants can still, in jurisdictions that still have funding, they can still get cases abated, they can still get their cases dismissed, and landlords can still recover rent from agencies if the landlords comply. The question for landlords is, does it make sense to accept these funds? Are there legitimate funds out there? Does it make sense for me to participate based on my specific facts with my specific tenant? Well, that's going to be a question for you, but today I'm going to break down the rules of this 56th emergency order and what it means for you and your eviction. Now, for those of you who have watched other videos of mine, you know that from time to time I will come and explain in pretty plain English what is meant by these rules and why they are in place. Today I'm going to do the same. So on October 14th, this emergency order says, the U.S. Department of Treasury announced that TDHCA and 3 local jurisdictions in Texas will receive additional rental assistance funds totaling, here we go, $32,898,397. So because of that, now the TDHCA has these additional funds, these counties have additional funds on top of funds that certain counties already had. So in Houston-Harris County, there are multiple agencies that never stopped giving out rent relief funds, and so those funds just now got a $32 million boost. So what this means is, if it turns out that there are active applications prior to October 14th, these may now be more seriously considered, whereas before this funding, maybe they didn't really have much of a hope. But now that the $32 million is out there, the agency has funds that you as landlords might well receive from your eligible tenants if they file the application and if you request those funds from that agency. And for those of you who've never dealt with the rent relief program before, this is not a scary proposition. If the tenant is eligible, you may be entitled to recover directly from the agency funding that pays back all of the months of unpaid rent, and in some cases, even future months of rent, so that the tenant can stay in place. Your obligation then is to waive late fees, to accept all of the rent as then current, and of course not to evict the tenant during the months for which rent has been paid. However, if your tenant subsequently violates the lease or subsequently fails to pay rent and there is no rent relief in place, of course you can proceed with an eviction. If you have previously accepted rent relief funds, you may find yourself in a predicament in a court that says, well, because you have a pending application or a prior application with an agency to recover rent relief, and right now the tenant is requesting rent relief from that same agency, I'm going to presume that you have not otherwise withdrawn your application, and I'm going to abate your case. And you may find yourself totally shocked that your case is being put on hold because your tenant requested funds, even though you have no interest in accepting those funds. So the rules clearly say that if the plaintiff and landlord have a pending application for rental assistance involving that defendant tenant, that the case must be abated for no fewer than 60 days. That means that everything is put on hold. In fact, The order goes on to say that along with the abatement, every part of the case is scrubbed from the record as if it never existed. The entire matter is made confidential, but the court is obligated to let all parties know that the case can be reinstated if the parties so choose. Now, generally speaking, this comes when both the landlord and the tenant are active and willing participants, but it can occur that a judge may abate the matter even if you, the landlord, are not a willing participant, particularly if you cannot demonstrate to the court that you have in writing disclaimed and withdrawn all previous intentions to have participated in any rent relief. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. Some judges presume that because the tenant has requested rent relief, that you, the landlord, are already on the hook. If that's the case for you, you're probably in a bad spot. You may want to seek out legal counsel in order to get clarification on these points. But for the most part, if you have previously accepted rent relief and have not otherwise unconditionally withdrawn your intent to receive any future funds from that or any other agency, you might find yourself involuntarily subject to a 60-day abatement. You're going to want to look into that before you show up to the courthouse. In fact, what you could do is show up to the courthouse with proof, some kind of written notice that you've sent to the rent relief agency that you previously had interaction with, indicating that you have informed them that you have zero interest in accepting funds, if that turns out to be the case. Otherwise, you may find yourself in the middle of an abatement and then having to prove to the court that you are no longer interested in these funds. And that's how reinstatement works. To reinstate a case after it has been abated, that is, the plaintiff is saying either A, the funding has been denied, or my tenant is not eligible, or I've had a change of heart and I no longer want to wait out this time, or I'm no longer interested, even if the funding is available and even if my tenant is eligible, I'm simply not interested in participating. You have the right to say no. And if that's the case for you, there's a procedure to reinstate your case so that you can get your eviction. The procedure involves the plaintiff filing a motion with the court to reinstate the case onto the court's docket. Remember that the abatement automatically scrubs it from the record as though it never existed. It's still there, the court knows it's there, but none of the public can see it unless you file this motion to reinstate. You'll need to supply evidence to the court that either funding has been denied, funding is no longer available, or that the tenant was ineligible, or that you have sent written notice to the agency that you are no longer willing or interested in participation and will not accept funding even if the tenant is eligible. If this motion is filed with the court and the necessary proof is submitted to the court, then the court will reset the case onto the court's docket. The confidentiality will be removed so that the public can see that the case is there and the matter should move forward. If, however, the 60-day abatement comes and goes, it goes all the way through, that case is dismissed, and the court doesn't actually have power beyond 60 days to do anything with your case. If your case was abated and during the 60 days you failed to properly file a motion and properly reinstate your case back onto the court's docket, unfortunately, by operation of this order, that case is dismissed. You'll have to refile your case and begin from scratch. Please note that this order requires that all counties inform tenants of their rights to seek out rental assistance. In fact, every citation for eviction that goes out must have the following language in place. You may be able to have some of the rent you owe paid and stop your eviction. Find out more about available rental assistance programs in your area at, and then this website is given. Again, this is necessary language. It is ordered by the Supreme Court of Texas. It must appear in every citation for eviction. If you were wondering how tenants were finding out about these programs, that's how. Additionally, this order requires courts to allow, if available, representatives from legal aid organizations or volunteer legal services to be present in person or remotely to provide information, advice, intake, referral, or other assistance for eligible litigants. In other words, if you've shown up to court and seen some legal aid attorney talking to your client, that's by design. Particularly in metropolitan areas like Houston and Dallas and San Antonio, you may have had experience where these attorneys are there and all of a sudden your tenant shows up with legal counsel and you don't have your attorney with you, but you're there arguing your case and they're winning based on the legal arguments raised by the legal aid attorney, which the tenant paid $0 to get. If available, the court cannot stop these legal aid attorneys from speaking to the tenants and assisting them based on their eligibility. So what can you do if your tenant mentions to you their interest in a rent relief program? What can you do if you show up to trial and your tenant is speaking to a legal aid attorney and things have gone totally sideways with your case? You are strongly encouraged to seek out an attorney in your jurisdiction who can assist you. Throughout this video, you've probably seen my phone number, you've probably seen our email address. Don't hesitate to ask us questions if you have them about the rent relief programs available in your county or how rent relief works in Texas courts. If you have these questions, you can send them to me through email, you can text them. You can even leave a comment for this video. I routinely answer your questions and comments that you post to these videos, your email and your text. We take a look at all of that and we're happy to respond. If you need something more in-depth, you might want to book a consultation, particularly if you're in the Houston area or really anywhere in the state of Texas. We're happy to help out landlords who are seeking advice when it comes to rent relief or other landlord-tenant related matters. In any case, I wish you the best of luck, and as always, landlords, happy leasing.